As folks know, we have a 6-3 conservative majority on the Supreme Court. Over the course of the past, well, even less than 2 decades, the court has moved considerably to, I guess one could say, the right in its sense of the constitutionality of people carrying firearms in this country and just how sacrosanct of a right that is. Joining me now is Elie Mystal. He is the justice writer for The Nation magazine, who's written a fascinating piece on a fascinating development, asking the question, why are public defenders backing a major assault on gun control? Elie, welcome to the program. Did I get your title at The Nation right? What was
I
it?
think the official one is Justice Correspondent, like
Justice Correspondent. But
International Man of Mystery.
There you are. Elie, I mentioned this before we started to record here, that I found your piece to be fascinating, exceptionally well written, and the issue itself is fascinating, both on a legal sense and in a just sort of a societal sense, and also from a political standpoint, which I want to touch on as well. But first, let's just start. Give people a little bit of a primer of where we are in terms of the ascension, I guess, of the Second Amendment that is really only taking place, and I don't think people fully appreciate this. We're only about 15 years out from when the right to carry an arm became an individual right in this country.
Yeah, so just to set the stage here, in general, over the course of our lifetimes, the Supreme Court has gone further and further and further to the hard right in terms of gun liberation law, while the country as a whole has steadily moved quite leftist towards supporting kind of reasonable gun regulation. So you've got, background checks, for instance, are, polling at some of their highest level ever, while the court itself is moving further and further right on this issue. The key here has been the ascension of the NRA's interpretation of the Second Amendment. Now, this is new. It's new in terms of, this was not how anybody talked about the Second Amendment back in the 1960s, let's say, right? It was really, if you go into NRA history, there was a revolt in Cincinnati, and blah, blah. It was when the hardliners took over the NRA from the inside out in the mid 70s, that this new interpretation of the Second Amendment started to get wings. And that new interpretation, which I can't emphasize enough, is not how the amendment was interpreted constitutionally for the entirety of our history, was that the gun ownership is an individual personal right that we get from the Constitution so that we can defend ourselves from criminals. That is, again, new. The original Second Amendment was thought to be something to protect ourselves from tyranny. It was thought to be something so that we could arm state militias, which were, and I don't want to be controversial here, but state militias just so happen to be critically important to putting down slave revolts in the early country. That's why the Second Amendment is there, so that the militias were not going to be controlled by the federal government, the anti-slave, potentially federal government, and could be still controlled by the pro-slave states, so they could raise their militias and put down revolts. That's why it's there, folks. But from the 70s on, the NRA has been pushing this individual right to bear arms, and that got, finally recognition from the Supreme Court in DC versus Heller in 2008, written by Antonin Scalia, where he created, and again, this is an allegedly originalist judge, where he created, for the first time in American history, a personal right to own a firearm for self-defense. And that is where the state of the law is right now. There's allegedly a constitutional right to own weapons for self-defense. And the current court, where we are kind of now, let's go from 2008 to now, what the current court is doing is expanding the zone of that right, of when you can use that personal right for self-defense, ever further and further and further away from your house. The issue of the day, the issue that the Supreme Court will take up next term, is whether or not the simple act of requiring a license, a gun license, before you are allowed to take your gun outside of your home and personally defend yourself in the streets if that's what you need to do. Whether even the permitting requirement in a state like New York, where this case is brought, whether or not that itself is unconstitutional, an unconstitutional restriction on this new personal right to bear arms. That's the case in front of the Supreme Court this term, and this piece that I wrote is talking about both the kind of white rural interests that brought this case. They're called the New York State Rifle and Pistol Association. And this melding of these kind of rural white interests and kind of more urban, more ethnic black and brown interests who have now joined with those rural interests towards trying to overturn literally New York State's permitting laws, and whether or not New York State has the authority to even require a gun permit.
And we should say, just before we get into the specifics of those of this case, we should say that this is starting with Heller. There is an ongoing process, like you say, to expand that circle in which you can leave your home with a gun. And if there is any ability of municipalities, of states, the federal government, to in any way put any type of restriction on that process of picking up my handgun, holding it up in the air, walking outside, whether maybe it's not just a handgun, maybe it's just like my Uzi, and stepping outside essentially and waving it around, and walking down the street and just going, hey Bill, hey Marge, how are you? Here's my Uzi. And this process that we're engaged in is basically this court every time, basically saying, no, you can't prevent them from having an Uzi as opposed to, a single bolt or rifle. You can't prevent them from not waving it around. You can't even require them in this instance to have to register it or get a license or tell anybody they have it. It's just like, it's going to be just like coffee can. And it just so happens that this is designed to kill people. And so this is an ongoing process. This gets pretty close to the end game, doesn't it? I mean, like if you get rid of the ability of New York State to say you need a license to carry a gun, what's left?
It's hard to imagine what gun regulation law survives at this point, right? It's hard to imagine.
No personal ownership of tanks or bazookas, maybe?
Most likely no nukes, but that's probably under like controlled, like you probably can't have a nuke because of the plutonium, not because of its killing power under this court, right? And I'm not being hyperbolic with that. Like it becomes increasingly hard to imagine the thing that the state is allowed to restrict if the current conservatives on the Supreme Court, and again, there are 6 of them, have their way. And again, I just can't emphasize how much they have changed the nature of what the Second Amendment is even supposed to mean or was supposed to mean over the course of, over the course of the country's lifetime, to say nothing of the changes over the course of our lifetimes.
Hi, folks. Sam Seder here. Catch the exclusive version of this show on The Choice from MSNBC on the Peacock app at 4 p.m. daily, at least Monday through Friday. That's Eastern, 4 p.m. Eastern.